listening to Driving Law, a podcast by Kyla about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
I should be wearing a hat.
You should be wearing a hat. We both should be wearing, nightcaps and at our homes and in our beds and asleep.
Been a long week, travel and lots of hearings and you name it, just like complexity of life.
Yep. It's been, I don't even know. I feel like Monday was like six months ago.
Yeah, I was trying to describe the decision we got from the court on Monday and a matter that we've got to other staff. And I was like, was it 6 months ago or was it? It was Monday. It was Monday. It was Monday.
It was Monday and today is Friday. Yeah. Anyway, it's been a very eventful week. We've accomplished a lot.
Yes. It was. Both of us are depleted and it's Friday afternoon. So usually we're trying to record the podcast earlier than this. And I look like I am frazzled. And I am.
There you go.
You, as always, look just fine.
Well, thank you. I just love looking just fine. I really appreciate those kind words.
Take what you can get.
Wow. Okay. Speaking of taking what you can get, the Ontario Court of Justice basically told that to an accused in an impaired driving trial and also said, hey, police, take what you can get in terms of trampling all over the rights of accused individuals who were pulled over for roadside breath testing.
This is such a disturbing thing. And I was thinking about the implications of this decision today as I was conducting hearings in other matters. You're going to have to lay it out, but it is one of the more upsetting decisions we've seen in a while. And from my perspective, clearly wrong. And the problem is...
Yeah. So basically, this case is called Jurlo, and Mr. Jurlo is pulled over. He's self-represented at trial. He's given an approved screening device demand, so a roadside breathalyzer demand, and the issue arises at trial about whether there were adequate grounds for the demand. There's two types of approved screening device demands. One is the mandatory demand. They don't need any grounds. The other is the suspicion demand, where they have to have a reasonable suspicion of alcohol in a person's body. The Crown conceded in his trial that the officer, while he subjectively believed there was alcohol in Mr. Jurlo's body, that subjective belief was not objectively reasonable. Now, one would think, well, absence of reasonable grounds, reasonable suspicion, the demand would be found to be invalid.
I was going to say, an ASD demand is a warrantless search. It is a warrantless search that is only authorized if it's authorized by law. The authorization in law in the criminal code is two different types of demands that you can have. Either the police officer has a suspicion that is reasonable, so objective, and subjectively holds it that the person's got alcohol in their body and they operated a motor vehicle within the preceding 3 hours, or they make a mandatory demand, which is they pull them over, they just decided to make the demand.
Yes. So, the argument at trial, Crown says, is it doesn't matter, though. It doesn't matter that he didn't have grounds to make the demand that he did to take the sample of breath from this person that he was going to do without a warrant and while his right to counsel was suspended, because guess what? He would have had grounds to make the other type of approved screening device demand. And really, they're not mutually exclusive. They can, you can substitute one for the other. ASD is ASD. It doesn't matter the authority that gives you the ASD.
Yeah. So I was trying to set it up so you'll be on our side, I guess. But my point was that there's two different streams, right? And both of these streams to permit this demand to be made are outside of a warrant. It's without a warrant. It's a search conducted without a warrant. And it is a violation of Section 8 of the Charter because it's a deficient standard, and it's a violation of Section 10B of the Charter because you don't get your right to counsel first. And those violations are permissible, provided it complies with the law. So there's lawful authority to do it. And now what we've got is a judge saying in this case in Ontario that it doesn't matter whether or not the police officer didn't have the grounds to make the demand pursuant to one section of the criminal code, which speaks of the suspicion. They could have just made a mandatory demand anyway.
Yeah.
They're
Like
different.
a fallback.
They're different. Yeah, like a fallback. And so therefore it's okay.
Which brings me to the like weird question of, if that's the case, then why even bother having the suspicion demand at all? Why even bother? Because if you don't actually have to have a reasonable suspicion, like, why did Parliament write and preserve the reasonable suspicion standard and the suspicion-based demand if they didn't intend for an officer to have to select the right demand for the circumstances and use it appropriately? It basically, like, ignores the fact that Parliament didn't need to keep it in the code, and their choice to do so says that they intended to separate the two.
And you can see reasons why they would have separated the two. One of them is, I have a suspicion, and it comes out in the demand. I, as a police officer, have a suspicion that you've got alcohol in your body. That is why you must comply with the demand. The other one is, I pulled you over. This is just a screening test. There's no, ifs, ands, or buts about it. I've got my device right here, and I'm going to make you blow. They made the decision for a reason, and that is knowing that both of these things are on the verge of not being charter compliant.
Also, can you, like, if you think about the amendments to the code and what the purpose of those amendments was, one of them was to streamline and simplify impaired driving prosecutions. How does it streamline and simplify impaired driving prosecutions to have people make arguments that reasonable suspicion didn't exist because it's still a standard in the code and still a standard the officer relied on, only for it to become irrelevant? Like, that doesn't simplify things. That just adds a layer of pointlessness that wastes court time, which is the exact opposite of what Parliament was after in making the amendments.
Yep.
Man, I'm so mad.
Yeah, well, the worst of this is that this was a circumstance where Crown Counsel was making this argument, and you've got a self-represented.
There was amicus.
I know.
But still,
you've got somebody who's a lawyer has been called in to make the argument, basically, on this, I guess. But it's a situation where it's not necessarily somebody who does this all the time. You and I presented to Parliament about this particular issue, right? And so here we are. Now we've got a judge deciding that basically can ignore the history of multiple different demands.
Well, and you mentioned, too, that it's a warrantless search. If you think about it in the context of warrantless searches, if you go and you get a search warrant to search somebody's house because, I don't know, Johnny Bravo phoned you and said, I saw this guy carrying a handgun into his front door. Can't have handguns in Canada. So the police go and get a warrant on that. And for whatever reason, Johnny Bravo, not a credible witness, they left it out. The grounds to issue the authorization did not exist.
It was a water gun.
But the police did not include in their search warrant application that it turns out CCTV from the neighbor across the street captured the guy bringing a handgun into his house, and that had been voluntarily provided to police. It's not as though they can just turn around and go, well, actually, we did have a legitimate basis that would have been unassailable to do the search. So you should just give us our warrant anyway, even though we didn't rely on this evidence.
Yeah. So now what happens, of course, when you've got somebody who is self-represented, has been convicted, will it end up being appealed?
Probably not.
And I think a higher level of court would probably, appreciate your argument that you just made there, that, the lawful authorization has to be the lawful authorization that you've got. You can't just pick a different lawful authorization just because there is another route.
Now, I mean, I do understand the judge does go through the alternative analysis of, even if I'm wrong, I'm still going to consider whether the evidence would have been admissible under 24-2, and then says, well, yeah, I mean, like, given the existence of the mass provisions that you could have easily met, I find it should be admissible.
Should be admissible.
Like, if I had to get there, it would have been admissible. I wouldn't have excluded it, which is also wrong because the Supreme Court of Canada said in Zacharias that if you have something that is obtained in contravention of the charter that is then used for a later authorization, like an ASD result for a breath demand, that you cannot rely on the contravening thing, and it gets removed from the equation. It gets excised from consideration, it is not a 24-2 analysis.
It is the same as, it's a similar analysis to a warrant. This is your lawful authorization for the next step.
Yep.
Your lawful authorization starts with this compromised process upon which you've gathered this evidence. It'd be like if you beat somebody up to get the information that led to their next step, the information from them, the admission that allowed them to get the warrant.
Now,
it's so wrong.
yes, it is so wrong. I don't like it. The good news is, at least for you and I and our clients here in British Columbia, that this is not the law in British Columbia. This case has never been considered in BC, but also the BC Supreme Court has ruled that it is necessary to specify the type of demand that has been made. So.
But you know that prosecutors across the country are going to be whooping this thing out.
Oh, yeah.
Left, right, and center.
Big old, cross Canada Crown colleague conglomerate.
At the convention next week.
Yeah. Anyway, it's not great. Don't like it. Unhappy about it. But also, moral of the story, don't represent yourself.
Well, yeah, I don't want to take any moral from it. You should be able to represent yourself. We always say that justice is going to happen one way or another, but the reality is that no.
No, because the government is going to outwit you with their lawyers. So
Yes.
Why would you put yourself at a disadvantage?
It's the little guy against the big machine. And if you are...
It's little guy against the big machine, even if you have a lawyer.
That's the thing. It's the little guy against the big machine. You've got the government is already so well equipped and has all of these resources at their disposal. And here you are, you've just got to sort of put together the best you can with your counsel.
Apropos of nothing, Paul. They sure do get to spend a lot of money and waste a lot of time arguing cases that are doomed to fail.
They do that.
Apropos of nothing. Anyway, speaking of cases that are doomed to fail and why you shouldn't represent yourself, bad news for Uber drivers.
Sorry, Uber drivers, but these things happen.
Yep. So this is Yu Chen. He self-represented twice, made it even worse, made a bad thing worse. He got a ticket for, unsurprisingly as an Uber driver, using his electronic device while driving. What did he do? Tapped it to accept and decline a ride. As they do, we know, of course, that's not lawful in British Columbia. They should have been in the law, but they're not gonna. And so he goes to traffic court by himself, challenges the ticket, is aware that he's going to get points. Doesn't raise the issue of points with the judicial justice, who has no authority over them anyway, but doesn't raise it, doesn't bring it up in his sentencing submissions. He gets a fine reduction. And he tells the court he's a full-time Uber driver, and that it was going to impact him, etc., that he didn't have a lot of money. And then he finds out from Uber
that it's going to cost him his Uber.
It's going to cost him his Uber because you can't have 4 points in 1 year.
Yeah.
So, actually,
cell phone ticket is 4 points.
Yeah. So, 1 point over the limit. And took over the line. Sweet Jesus.
Sure. I'm not in the mood to sing.
No, I know. He tries to appeal his guilty plea, basically saying that it wasn't informed, that he wasn't aware of a legally relevant collateral consequence, which specifically is that he isn't aware of the legally relevant collateral consequence of what Uber would do to him as a result of the points. He knew there would be points, but he didn't know that Uber would do something to him as a result of those points.
Okay.
So, the court has to consider whether his guilty plea should be withdrawn. What do you think happens, Paul? Oh, and he's self-represented also in the BC Supreme Court.
Well, I predict that he wasn't permitted to have this plea withdrawn. That's my guess.
That's correct. The judge says basically points themselves are not legally relevant collateral consequences. There's law going both ways in BC, but it really comes down to, were you aware of the existence of points and that points were going to be probably added, or should you have been aware based on your experiences? They cite the case of Zhang, which may or not have been somebody here in this room right now.
Yeah.
But, in saying that it was not a legally relevant consequence that accused, who was aware of the concept of points, didn't make any inquiries about the impact of the points on his driving record.
I think there's lots of points to this, and that is, people know that there's points. People should know that there's points. You get a driver's license in BC, you're notified of the fact that there's a demerit point system. It's on every government website. I mean, I think it's very hard to argue, I didn't know that there would be points when I entered my guilty plea. You might get lucky and it might be a ticket for which there is not points, but generally speaking, I think the expectation is, you know that there's going to be consequences. You don't know necessarily how Uber is going to deal with it.
Well, and this is part of the problem, the court says, is look, like what Uber's policies are, that has nothing to do with the government. You can't possibly call it a collateral consequence of a guilty plea because it's not something that's administered by government that they have any control over, or that you could assume that they would have knowledge of. It's like a private contract issue.
And that is the actual consequence.
It is a collateral consequence. It's not a legally relevant one.
Collateral consequence in your relationship with Uber, and it's no different than anybody else who gets a speeding ticket or 2 speeding tickets, and their company that they work for decides they're not going to employ them anymore in that capacity as a result of it.
Yeah. So then the court also makes this comment, because one of the things that Mr. Chen said is also, I wasn't even using my phone. I was just tapping for the rides. And the court's like, look, even if I get over the hurdle that his plea was involuntary or uninformed as to the consequences, you still have to establish subjective prejudice. And there's no prejudice because by his own evidence, he's guilty. Guilty.
Came into court to argue that he was guilty.
Came into court and said, I'm guilty.
Wanted to have his guilty plea unwound, but came into court to testify about the fact that he's guilty. G-I-L-T-Y.
Yes. Anyway, so that's disappointing. Interesting little last line, though. Paragraph 37, the court says, the second is that in coming to my conclusion, I've heard Mr. Chen's submissions with respect to the financial hardship that his conviction for using a handheld device may have on him, and I have some sympathy for him. However, while I appreciate Mr. Chen's submissions with respect to the unfairness of the legislation to people like him who require to use their devices as part of their jobs, I, like every member of this court, must apply the law as it is written. This applies equally to the basis for withdrawing a guilty plea as it does to the basis of the violation ticket itself. So we see that same language that we saw in the what was it, Berta case, on the tapping.
Yeah.
Well, the court's like, I'm sympathetic because this system is set up for you to fail.
Yeah. Uber has decided to use this system where you have to tap to accept the ride. And the government has accepted that Uber can come here, and nobody seems to have turned their mind to the problem of this. And sorry, it's up to the government. The government can write bad laws, as we've been reminded over the years many times. Government can write bad laws. It's up to the government, as long as it's constitutional.
As long as it's constitutional. All right. Speaking of governments writing bad laws, Paul, how would you like to pay child support to the government if you are an impaired driver and you kill the parents of a kid? You have no knowledge of who your victims are or going to be, or the fact that they're parents. Your crime has nothing to do with their status as parents. It's not motivated in any way.
This is Ontario's.
This is Ontario. Ontario. Doug Ford has all sorts of ideas. It was just coming around to the guy, and then this.
Yeah, I mean, it's something I haven't turned my mind to the constitutional validity of it.
Not constitutionally valid, in my opinion.
Yeah.
I'll tell you why.
Tell me why.
Because to do that is essentially to impose an indefinite sentence. If you're paying child support, like technically as a parent, you could theoretically be responsible for child support for the entirety of your child's life, because if you divorce and your child pursues post-secondary education, you're required to fund that education as part of child support. Even though, people who have loving parents who are in love with each other and on a cruise right now didn't get that. I'm not bitter. I'm not. This is very supportive and I love them.
That decision was from Jack Watson, who was my advanced criminal law professor and later went on to be a Queen's Bench judge and then Court of Appeal in Alberta. Very good guy. He was the one who ruled that you as a parent, have to pay for the post-secondary education. My dad was broke and my mom was not
Yeah.
overly helpful, and I wasn't about to sue either one of my parents for it.
Like,
But it was a little late for me. It was like I'd been a lawyer for 5 years. Any limitation period was already over.
are there limitation periods on unpaid child support? I don't think there are. As a matter of policy.
My dad's deceased.
No, it's too late now. Then.
Yeah. And my mom's in her 80s. I don't think it's fair to come after her.
What was your tuition back then? 85 cents and a pack of gum?
$3,600.
Oh, that's the same thing these days.
Yeah.
Isn't a pack of gum $3,600 in this economy?
It will be by the
Jeez.
time Trump's done.
Yeah, right. Okay, no. Yeah, I think it creates an indeterminate sentence. It effectively supplements the criminal law. It is abhorrently punitive. It's not rationally connected to the offense in any way, right? Like if you're talking about something, right, if you have the provincial government legislating in road and highway safety, in pith and substance, that has to be about road and highway safety. This is not. This is about punishing people and the government recouping what it would otherwise spend on like the foster system or whatever. The kids already have. The individuals who lose their parents already have a civil cause of action against the driver for wrongful death. And Ontario doesn't have wrongful death caps. So why is the government getting involved when the civil system is set up for exactly this purpose and creating what is effectively a life sentence for people?
Yeah, it's interesting. I was just thinking of cases that you and I have done where, there might be a guilty plea in the works, but even when there's maybe some viable defenses, but the person might be leaning toward pleading guilty to wrap it up and finish it, knowing at what the end of the sentence is going to be. But if you've got this indeterminate thing where, you've got maybe somebody's got an 11-year-old child that they didn't even know they had. Like,
the child with special needs requires like full-time support.
Yeah. You're not going to plead anybody guilty in those circumstances. You're going to run the trial till the end. Because
it's bonkers. It's probably cruel and unusual punishment.
But I've heard of this happening in the States.
Sure.
So, and we get acclimatized to the new bad, and then it's no longer considered cruel and unusual punishment.
Well, this is a message to you, Nikki Sharma, and Nina Krieger, if you're listening, and David Eby, if you're listening.
Oh, they're all listening.
No, they aren't. They don't care. They don't even know about the existence of this podcast, even though both Nikki Sharma and David Eby have been on it. They've forgotten it exists. Don't do it. Don't do it. You'll have to go through me. Don't do it. It's dumb.
That's a good reason to have to go through you. But,
Really annoying.
it's just a matter of time till the government changes. And if the Conservatives ever get into power in BC, they will certainly follow this path.
Dallas Brody, a Dallas Brody 1 BC government.
She's not going to be the one who's in power, but
Nope.
And I don't think John Rustad will. I think he'll get turfed before the next election. However,
This is not a politics
it's the type
podcast.
of thing the Conservatives could run on,
Yeah.
and people would probably support it.
All right, while we're talking about things in Ontario, would you like to know about our ridiculous driver of the week?
I know our ridiculous
You
drivers.
do know our ridiculous driver of the week. And you know what? I think we see one of these every holiday season, and yet every holiday season someone tries it again.
Yeah, and probably in the next few weeks, we're going to have somebody who's driving with like this much view of their like goggles view only out of their windshield, or looking through their.
We should
Looking
really
at
like have a bingo card for ridiculous drivers that come up frequently enough. Like, people crashing into things that you don't normally drive into.
Yeah, people doing something stupid while they're in their vehicle. I noticed you
Wait a
did it.
minute, that's every.
You did no, I mean you did a TikTok this week that's
Can you jerk it or drive?
very popular. Everybody wanted to know whether or not you can jerk it while driving.
The comments, honestly, go to my TikTok just to read the comments, because the comments
That's
are
a pretty-
hilarious.
Comments are pretty good.
Yeah.
Yeah. But yes, this person was not doing that.
Nope.
Oh, they should not feel the stigma of that. So it was something else. But from Ontario, the other Florida of Canada, Alberta being the
21-year-old driver, big old pickup truck. What is that? A GMC? A Ford? I don't know.
as a GMC. I'm looking at the
GMC.
bumper.
Yeah.
Step bumper thing.
a lot of GMCs these days.
Well, it's a Chevy or a
in
GMC.
our lives. GMC, the guy's gone to a lot of effort to string Christmas lights in very nice, straight, parallel lines all over the entire body of the
They're not
pickup truck.
crooked, but it's evenly spread over the truck. Like, yeah,
It looks pretty.
yeah. But of course, you can't have red
Right.
or blue lights, particularly on your vehicle. Blue lights.
Unauthorized lamps at all.
Yeah.
Yep.
Although there's lots of guys driving around with like lights underneath the body and things like that. You can switch those off. But this guy's driving around with a full set of Christmas lights wrapped all the way around it.
Yeah. I mean, he didn't make things better for himself. He probably might have got off with a warning if he hadn't also been going twice the speed limit
Well,
at 21 years old.
Okay. So soon he'll be a listener to the podcast, and he will learn to not put himself in these situations. But this is something that happens every year. Somebody decorates their vehicle with, and it really comes down to how easy lights are these days. And but LEDs using so little power, you just use an inverter in your car, which I prefer to call an inverter. Because so you could see why with the ease of it, that people would think this is a natural next step, especially those who are so enthusiastic about Christmas. Now, someone like me,
Grinch,
who hates Christmas,
bah humbug,
exactly, never do such a thing. So,
will you wire up my car for Christmas? I love Christmas.
Yeah, if you want to be the ridiculous driver of the week,
I'd probably get a warning first.
you and I are pretty.
I wouldn't get a warning. They'd be like, Kyla Lee, I'm going to give you a ticket for each light bulb. Each light bulb is an unauthorized lamp, so you could theoretically get like 85 tickets.
We are ridiculous in other respects than driving. There is no doubt about it.
Yes.
We're just discussing it this week, like what two lawyers get together and release a crazy calendar every year, or send police chocolates for Valentine's Day, or
record a Christmas.
Last year we recorded our fantastic Christmas song.
And maybe there'll be one this year too.
Well, we'll see. Time's a ticking.
Yeah, I know, time's a ticking. I'm on it, okay? Anyway, that's our podcast. If you have a driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.